What is Article 370? Why has it become a sensational topic in the recent days? What has the Indian government done that almost all national parties are opposing it? Article 370 of the Indian Constitution gave special status to Jammu and Kashmir, a part of the larger region of Kashmir, allowing it to have separate constitution, a state flag and autonomy over the internal administration of the state. Little bit of history. In October 1947, the then Maharaja of Kashmir, Hari Singh, signed an instrument of accession that special three subjects on which Jammu and Kashmir would transfer its power to the Government of India, namely Foreign Affairs, Defence and Communication. So in March 1948, the Maharaja appointed an interim government in the state with Sheikh Abdullah as Prime Minister. In July 1949, Sheikh Abdullah and three other colleagues joined the Indian Constituent Assembly and negotiated special status for Jammu and Kashmir, leading to the adoption of Article 370. He wanted an ironclad autonomy for the state, which the centre didn't comply with. The controversial provision was drafted by Sheikh Abdullah. So, it essentially means Indian Parliament needs Jammu and Kashmir's government's approval for applying laws in the state, except in cases of defence, foreign affairs, finance and communication. The article was drafted in Part 21 of the Constitution, Temporary, Transition and Special Provisions. The article was enacted based on the condition that Jammu and Kashmir Assembly will apply the article of the Indian Constitution for its states or to abrogate the article altogether. The Government of India revoked this special status in August 2019 through a presidential order and the passage of an resolution in Parliament. What are the provisions of Article 370? Except for defence, foreign affairs, finance and communication, Parliament needs the state government's concurrence for applying all other laws. The state residents live under a separate set of laws, including those related to citizenship, owner of property, and fundamental rights as compared to other Indians. Citizens from other states cannot buy property in Jammu and Kashmir. Under Article 370, the centre has no power to declare financial emergency under the Article 360 of the state. It can declare emergency in the state only in case of war or external aggression. The union government can therefore not declare emergency on grounds of internal disturbance or imminent danger unless it has made with the concurrence of the state government. Applicability of Indian laws to Jammu and Kashmir. There are only a handful of Indian laws which are applicable to Jammu and Kashmir, like the All India Services Act, Negotiable Instruments Act, Border Security Force Act, Central Vigilance Commissions Act, Essential Commodities Act, Hajj Committee Act, Income Tax Act, the Central Goods and Services Act of 2017, Integrated Goods and Services Act of 2017, the Central Laws, extension to the Jammu and Kashmir Act in 1957 and 1968. The non-applicability of National Human Rights Commission Act by claiming resources to Article 370 was set aside in 2010. The abrogation. In 2014, the then Government of India tried to abrogate the article and integrate the state with the Union of India, however in vain, as the High Court of Jammu and Kashmir ruled that Article 370 cannot be abrogated, repealed or even amended. In 2018, the Supreme Court of India gave a similar opinion declaring the Article 370 has acquired a permanent status. It stated that since the State Constituent Assembly has ceased to exist, the President of India would be able to fulfill the mandatory provisions required for its abrogation. The President of India would not be able to fulfill the mandatory provisions required for its abrogation. On August 2019, the Home Minister of India declared that the President of India has issued a presidential order CO 272, CO stands for Constitution Order, under which Article 370 supersedes the 1954 order, shall come into force at once and shall thereupon supersede the Constitution Order 1954 as amended from time to time. Let's get to the issues with the abrogation of Article 370. There are two important issues with the abrogation of Article 370. First, the most important part of 370 was the provision to Clause 3. Second, the concurrence of the government of the state of Jammu and Kashmir has to be taken. Let's get into the details one after the other. So, getting into the details, first, the provision to Clause 3. Clause 3 itself authorized the President to pass an order removing or modifying parts of Article 370. Constitution Order 272, however, takes an entirely different path. Constitution Order 272 uses the power of President under the Article 370 of 1 to indirectly amend the Article 370 of 3 via a third constitutional provision, Article 367. Article 367 provides various guidelines about how the Constitution may be interpreted. Now, Constitutional Order 272 adds to the Article 376 an additional clause which has 4 subclauses. Article 370 of 1 allows the President, with concurrence of the government of the state of Jammu and Kashmir, to amend or modify various provisions of the Constitution in relation to Jammu and Kashmir. Article 370 of 3 proviso states that Article 370 itself has to be amended by the concurrence of the Constituent Assembly. Constitutional Order 272 therefore uses the power under the Article 370 of 1 to amend a provision of the Constitution, Article 367, which in turn amends Article 370 of 3 and takes out Constituent Assembly's concurrence for any further amendments to the Article 370. And this in turn becomes the trigger to the statutory resolution that recommends to the President the removal of Article 370. There is a second important point to be noted here. Constitutional Order 272 states, as it must, that the concurrence of the government of the state of Jammu and Kashmir has to be taken. However, Jammu and Kashmir has been under President rule for many months now. Consequently, actually the consent is that of the governor. However, there are two serious problems with basing Constitutional Order 272 upon the consent of the governor. The first is that the governor is a representative of the central government, like the president. In effect, therefore, the Presidential Order 272 amounts to the central government taking its own consent to amend the Constitution. Therefore, first, on the indirect amendment of Article 370 of 3 proviso via Article 370 of 1, and secondly, on the use of governor as a substitute for the elected assembly in the matter of this kind. I would like to conclude that there seems to be a legal and constitutional problem with Presidential Order, Constitutional Order 272, which of course forms the basis of both the statutory resolution and the reorganization bill. Thank you.